Businessman Vuzamuzi Cat, Matlala has formally withdrawn from his plea and sentence agreement with the National Prosecuting Authority, NPA, and the Investigating Directorate Against Corruption, IDAC, in the high-profile 228 million rand SAPS Medicare 24 tender corruption case. The development follows proceedings in the Pretoria Specialized Commercial Crimes Court. Matlala, linked to his company Medicare 24, had pleaded guilty to fraud, corruption, and money laundering charges relating to the allegedly irregular SAPS tender. The plea agreement proposed an effective 8-year prison sentence in exchange for his cooperation and testimony against other individuals, including high-ranking officials connected to the investigation. On July 1, 2026, Magistrate Ignatius Dupreez rejected the proposed 8-year sentence as too lenient and indicated that an effective 12-year prison term would be more appropriate. Matlala was given the option of accepting the longer sentence or withdrawing his plea, and he elected to withdraw.
We still withdraw from the plea, which my client just wanted to know about the practical, the way forward practically, what's going to happen. He didn't have full details.
Thank you. Mr. Matlala, I've been informed by counsel on your behalf in respect of yourself, accused 2 and 3, that it is your choice to withdraw from the plea and sentence agreement as you decline to accept the court's recommended sentence. Do you confirm in respect of yourself that is the position? Accused 2? Do you confirm?
Yes.
And accused 3? Thank you. The plea and sentence agreement is then to be regarded as null and void. Date?
The 11th of September 2026, Your Worship.
Which the date was not discussed with me. If you can just bear with me, please.
Sure.
The matter has now been postponed to September 11th, 2026 for further proceedings. The withdrawal means the plea agreement has fallen away and the guilty plea has been withdrawn, returning the matter to trial. Prosecutors will now prepare for a full trial, while evidence or admissions linked specifically to the plea agreement and Matlala's cooperation against other figures may be affected.
Our own evidence, if it leads to all of them again, therefore they will be arrested as per the way we did with the other ones. Obviously, we don't know what is happening behind the closed doors somewhere. Therefore, we will just take it as it is. That's why, if you see, the magistrate doesn't only take what the lawyers are saying. They've got to confirm that you, as the accused, agree. And that's what was important. And therefore, we really do not want to speculate on what the reasons might be. We had the deal arranged and finalized. The only thing that changed was the sentence. Therefore, we expected him to accept it, but we don't know what would have happened behind closed doors.
Do you felt as though that he was willing to comply? I mean, he did initially plead guilty to those 7 counts.
Yeah, definitely we thought. Obviously, we wanted that to happen because we wanted to move and finalize this case. It's not only because of the people that we go in to get, but also it will reduce the time to deal with this matter because now we don't have to go all the way and then deal with this matter. It will be in our interest that this matter is finalized quickly. But now it means we are going full force with the matter, and then obviously we will see how it goes.
Mr. Kanyako, this is certainly quite a big blow, because you would remember that the presiding magistrate, in handing down that judgment, basically spoke about Mr. Matlala being the kingpin, having done this out of greed. He was the chief orchestrator, if I can, of everything that happened. He started the process. He was the one who paid gratification to other individuals who've now also been dismissed from the South African Police Service. So this is quite a blow in that the main man, I would say, that the NPA was looking for, and you believed that today would bring some finality to the matter, basically bombed.
It is a blow in as far as the police is concerned, but not in as far as the matter, the case is concerned, because you must remember, because of all of those things that the magistrate said, he was already accused number 1 in the other case. And that is purely because we believed even there that he's the mastermind behind the whole thing. That's why it is the other cases, Matlala and others. Therefore, we still have evidence against him, and he knows that we have got the evidence against him, and that is why he's accused number 1. And we are saying, let's go to the other matter and then make sure that we get conviction on that matter.
This is the statement released by NPA. It reads as follows. July 13th, 2026. The NPA to proceed with the case amid Matlala's plea withdrawal and notes Matlala Commission proceedings. The National Prosecuting Authority, NPA, notes Mr. Vazamuzi Kat, Matlala's decision to withdraw from the plea and sentence agreement, in respect of which the magistrate had rejected the proposed sentence before the Specialized Commercial Crimes Court, Pretoria. This follows a previous postponement granted by the magistrate for the legal representatives to reflect on the magistrate's proposed 12 years imprisonment sentence. Mr. Matlala had pleaded guilty to charges related to the Medicare 24 Tshwane district contract, resulting in him being separated from his 16 co-accused. It is worth mentioning that the genesis of the proposed plea and sentence agreement is that Mr. Matlala voluntarily approached the Investigating Directorate Against Corruption, IDAC, to propose a plea deal which ultimately led to discussions between him, through his attorneys, and the state. This turn of events meant that the matter had to be postponed to September 11, 2026, wherein Mr. Matlala will rejoin his co-accused as the plea and sentence agreement being declared null and void. The NPA holds the firm view that his withdrawal will not negatively impact the IDAC's case against the 17 accused, as we believe there is sufficient evidence to sustain the charges preferred against all the accused in this matter. We assure the members of the public that a plea and sentence agreement is a legally recognized and legally viable strategic mechanism of preventing a protracted trial by concluding same with a cooperating accused person against whom the state has a formidable case and to get evidence that was not readily available. It is certainly not an indication of the state's lack of confidence in its case. The IDAC is now focusing on ensuring that the pending trial proceeds without hindrance, said Advocate Andy Motibi, the National Director of Public Prosecutions. NDPP also indicated to the members of the public that the head of IDAC, Advocate Andrea Johnson, was scheduled to appear before the Matlala Commission and could not appear due to ill health. The NDPP calls upon all to allow the Commission to do its work unhindered. Inquiries. Kaiser Kinyago, NPA National Spokesperson.